And he was caught, he was arrested, he confessed, apparently under some kind of duress, he was beaten, threatened, and the chamber found no violation. Chamber applied holistic approaches and said he was legally represented during the trial. His confession was not the only basis of the conviction. He was able to challenge the prosecutor's case, and this is sufficient for us to find that there was no violation. The case was sent to the Grand Chamber, and in the Grand Chamber there was a huge difference to the approach of the Chamber, and this case is sometimes called a revolutionary case that changed really the terrain in the whole Europe, and of course changed, it was written a lot about that, changed the court's case law. If we are looking at what was the situation in Turkey existed a law that actually prescribed a general ban and said that in cases in which there was the possibility, or there was a terrorist or security questions involved, in such type of cases, lawyers were not allowed to participate in pre-trial proceedings. So there was a general ban. In this type of cases, you could not have a lawyer. The Grand Chamber, and I want, no, I don't want that. This is actually the real text about which I will be talking from the Saldos. There are a couple of paragraphs that are very important. Paragraph 55, 56, 58, and 62, I believe, is the last one, in which the court took the following standing. The court said that the lawyer should be provided as a rule. Access to a lawyer should be provided as from the first interrogation of a suspect by police. As a rule. Before that, we didn't have anything like that. And then we said, unless there are compelling reasons for excluding the lawyer. That's what the court said. First change that was done is, as a rule, it should be provided. Second change that was done, more stringent requirement, not for a good reason, but for compelling reasons now. And then paragraph 55 is actually talking about one type of situation, and paragraphs 56, 58, and 62 are talking about different type of situation. Two types of situations that Saldos is actually differentiating are one when there are compelling reasons, and the second one when there are not compelling reasons. So what did the Saldos say when there are compelling reasons? The Saldos actually continued the line of pre-Saldos case law and said that if there are compelling reasons, that in itself is not sufficient to find that fair trial rights of the accused were not breached. But the trial should be looked as a whole, and then it should be seen whether there really this didn't have prejudicial character for the suspect, for the accused. And then the court said, in such type of situations, in principle, it would be deemed that there was a prejudice for the suspect or for the accused if he has given incriminating statement and that incriminating statement was used for his or her conviction. So the court said, in principle, that means the exclusionary rule, if it is not applied, there is a rebuttable presumption of violation of the rights of the suspect. For the first time, Saldos introduced something new. And Saldos defined how the court should react if there are compelling reasons. And Saldos said that if the law says generally that there is no right to a lawyer, of access to a lawyer, that in itself already falls short of the requirement under Article 6. But Saldus didn't stop there. And Saldus said that if the statement is given in such circumstances, then it is considered that the applicant was undoubtedly affected by that, and in a way, Saldus created presumption juris et de jure of the violation or the breach of the rights of the suspect or accused, and after that, in addition, confirmed and said that neither the assistance provided afterwards, nor the adversarial nature of subsequent proceedings, nor the opportunity to challenge the evidence against accused could save the case. And now when we are looking at these, and at that what was said in Saldus, we could see that some interesting questions arise. Interesting questions. First, Saldus didn't say anything, didn't define in any way compelling reasons. So we don't know what are compelling reasons. We only know that compelling reasons are not general prohibitions in law. General prohibition in law cannot be treated as a compelling reason. Saldus failed to define when that right arises. So we have concurring opinions who are trying to explain that. Judge Bratza. Then Saldus failed to define scope and content of that right. Didn't say anything about that, but we have concurring opinion by Judge Zagabiensky and Judge Casadeva. And then Saldus actually didn't say anything about what is the relation between a right to a lawyer and exclusionary rule. Do we have one breach or we have two breaches? Could the not having the access to a lawyer in itself be a breach? Or it has to be accompanied by the non-exclusion of the evidence? Or these two could be two separate breaches. We could take different positions on that, reading Saldus. Then, in Saldus, we can find additional observations about things that were happening in that proceedings, that he was young, that he was minor, some other things. But the court says that the court further observes. So it's not clear whether the court really thinks that this should be taken into consideration and without that you cannot find a violation, or this is something which is said only because of excessive caution. And then the court didn't explain what is the relationship between the justification for a restriction, compelling reasons, and the right of access to a lawyer and overall fairness test. We can somehow, we can again maybe interpret that in two different ways. And when you read the judgment and when you read the concurring opinion, which Judge Judikivska and myself and two other judges have written, then you can see how you could go in two different ways trying to explain Saldus. And then we have post-Saldus cases that more or less went in one direction. And I won't comment them, that would be too long. But important case that came afterwards was Ibrahim versus the United Kingdom in 2016. And in that case, the court did three things. The court explained the two steps approach in analyzing the restrictions of the right of access to a lawyer. So somehow, there we can see and posit how Ibrahim and Saldus differentiate. What it did, It identified compelling reason. Okay, what the court did there, the court defined meaning of compelling reasons. That's not so spectacular. Then it defined criteria according to which overall fairness review should be done. And then it played with the two stages test that is applied in this type of cases. First stage, identification of whether compelling reasons exist or not, and the second stage, whether there is necessity to apply overall fairness test or not. So what the court said about the compelling reasons? It said that restrictions, first, are permitted only in exceptional circumstances, must be of temporary nature, and must be based on an individual assessment of the particular circumstances of the case. So it continued with this, what CPT has said and Saldus has repeated. And then it says, this is not sufficient. Relevant is also that the decision to restrict legal advice has to have basis in domestic law. So that has to be provided in law. You cannot apply it just like that. And the scope and content of any restriction on legal advice must be sufficiently circumscribed by law so as to guide operational decision making by those responsible for applying them. In short, this should be precisely defined, it should be foreseeable, mainly to limit the possible discretion of the authorities when they apply that. That discretion has to be limited. Furthermore, the court said that, and gave only one example of the compelling reasons. And the example the court took actually from the European Union directive. And this is the existence of an urgent need to avert serious adverse consequences for life, liberty, or physical integrity in a given case. Government has to demonstrate that convincingly. And then this was criticized. This was criticized by the dissenting judges, Judge Lafranc and Judge Shile, in two respects. First, they said, actually, this type of compelling reasons is unnecessary, and there is no necessity with this type of compelling reasons to not allow these statements to be taken into not to be excluded, to leave them. They should be excluded actually, because you are asking and interviewing these people for a different reason, in a different task, to prevent possible hazard to life, but not for something else. And that's why these statements should not be used. That's what they have said. And then they said the standard is not precise enough because there should be imminent danger. And anyhow, in the concrete case, was not applied properly because it was not applied to the concrete case. It was just in general said that were the conditions, and that's why they didn't have the right to a lawyer. But it was not in each concrete case demonstrated that there was really need not to have a lawyer, and why would be a need not to have the lawyer, because the lawyers were already there. So this is with the meaning of compelling reasons. Then two steps approach. Ibrahim and Saldus are two different cases. How they are different? In Saldus, you have a general ban. In this type of cases, terrorism, security for the society, danger for the society, in this type of cases, there is no right to a lawyer. Ibrahim is a different case. Ibrahim very precisely defines when the lawyer and under which conditions the lawyer cannot be there, and says in each particular case this has to be justified. So there is no general ban. They give conditions and then they say, and you have in each particular case to justify this. So when you are looking at the Saldus and when you are looking at Ibrahim, you could actually see that these two cases are partially overlapping and partially they complement each other. Where do they overlap? When there are compelling reasons. They say the same thing. When there are compelling reasons, you have to do overall test. They say the same thing. And we can say that Saldus is linear development of, that Ibrahim is linear development of Saldus. But when you are looking at a situation when there are no compelling reasons, then we can say that they actually complement each other because each of them is talking about a different situation, as I have explained. Saldus is talking about the situation when you have a general ban, and Ibrahim is talking about the situation when you do not have a general ban. The question after Ibrahim remained important question, and that question is whether you apply overall fairness test across the board, or you could find in certain situations automatic violation. And what Bös said was, no, you apply always overall fairness test. Even in situations, even in legal systems where there is no right to a lawyer in pretrial proceedings, and there were no compelling reasons, still the court would have to go and check whether the fairness of the trial was fine. So you could see how we have developed, where we have started. We have started when there are compelling reasons, you still have to go in and you have to check overall fairness. That's how we started. Because compelling reasons in themselves are not enough not to go into the case and to check whether overall fairness was okay. You cannot presume that overall fairness was okay if you have compelling reasons. Where we have ended with Bös, we are saying, even if there are no compelling reasons, even if in the legal system there is no right to a lawyer, and the judges do not have, or the prosecutors or the police, do not have obligation in each particular case to check whether there is a reason not to provide a lawyer and justify that. At the end, that could be fine if, at the end, Constitutional Court or, at the end, Strasbourg finds that overall fairness was okay. Whether we are fine with that or we can criticize that, I will talk a little bit more about that a little bit later. What else Ibrahim and then Bös confirmed are relevant factors for overall assessment. So when you are doing that overall assessment, what are you looking at? Vulnerability of the suspect, mainly age and mental capacity. Legal framework, the arrangements in pretrial proceedings, admissibility of evidence, everything related to that. Opportunity to challenge whether the accused has the opportunity to challenge the authenticity of evidence and oppose its use. Quality of evidence, to what extent it is reliable, accurate, whether there was any compulsion in obtaining it, and so on. Whether the evidence was obtained in unlawful way, and what kind of unlawfulness that was. What nature that statement by the accused had, and whether he or she promptly retracted that statement. Use to which that that statement was put, and whether that statement was significant part of probative evidence. Whether the assessment was was done by judges, jurors, lay magistrates. So all that, except the first one, are procedural guarantees. And all these procedural guarantees are taken from Saakashvili case, except the assessment done by the judges, jurors, lay magistrates, that was not there. But all others are taken from Saakashvili. Saakashvili is the case that is talking about the use of witness evidence that was given in pre-trial proceedings, and then witnesses could not be or were not heard at the trial. So it's interesting, you know, because these are two very different situations, and it's interesting that the court was trying to somehow take the same guarantees and put them here and said, this is what we are using when we are talking about the suspect or accused as well. This is strange. And then you can see the last element that is there, weight of the public interest in the investigation and the kind of the punishment that was given. This is also very interesting, what the court has introduced. Why? Because we are in Article 6. Article 6 is not absolute right. Article 6 is not qualified right. Article 6 is unqualified right. So for the first time, court has said that you can take this right in name of the public interest. And court said it twice. First time in defining compelling interest, and second time in relevant factors for overall assessment. And I must say that I find that quite dangerous. Why? Because when we are talking about qualified rights, Convention has very precisely defined when and to what extent you can limit Article 10, Article 8, Article 9, Article 10, and other qualified rights. Here, Convention didn't say anything. Court introduced that, and the standard is much vaguer than it is in relation to the qualified rights. So the question is, what are we doing? That's why I think that in terms of the Grand Chamber judgments, maybe this is not the end. Maybe it's the end for now that we have such insistence on subsidiarity, such a fear of populism, such emphasis on neo-sovereignty, such fear of multilateralism, and so on, things that are happening in our society, that are reflected in the court, when we have terrorism, when we have such threat of organized crime, and I don't know what. All this, that context, certainly plays a role in the way how the court is phrasing certain things. So these are very interesting things, I would say. Then, what really versus Belgium said a week ago. So, as I have explained, it has clarified Ibrahim two-stage test and interpreted it as linear development of Saldo's. And the court actually said there was never automatic violation when lawyer was not there. There were a couple of cases saying that, mainly Turkish cases, but otherwise nothing else. You could read the concurring opinion that is trying to say differently. And then you can judge for yourself. The fact that there is a general and mandatory restriction does not remove the need for the authorities through individual assessment whether there are any compelling reasons. That's an interesting paragraph in the judgment. What this paragraph is actually saying. The paragraph is saying that there is a mandatory restriction, like in Belgium or like in Turkey. But even when there is this general mandatory restriction, you as a judges have to go there and have to see, or prosecutors or policemen, whether, you have to assess whether compelling reasons are there. That's all fine. Once Saldo's is there and we know that is requirement, and once there's a precedent. But of course, that depends upon the domestic legal system. So if domestic legal system is, as in Ukraine, as I heard today, where you have directly to apply our case law, then of course you are looking at our case law and you adjust your system to that. And so that means if you don't have all of that in your legal, prescribed in your legal system, you take that from our case law and you apply it directly and you might be fine. But if you cannot do that, as in Beurs, in Belgium, the court was trying to do, and the court itself said, sorry, we are looking at Ibrahim, we are looking at Sudos, but our national system is not allowing us to do that. We are incapable of doing that. Then it's really questionable whether we can apply the standards of overall fairness, really. Okay, I will stop here and then you can ask me questions and we can discuss. Thank you.
Дуже дякую за цю доповідь. Дійсно, питання дуже складні і враховуючи той факт, що стосовно України, в тому числі я дивлюся на це з своєї точки зору, з точки зору виконання рішень Європейського суду, на розгляді зараз перебуває в Комітеті міністрів Ради Європи така група, як Балицький та інші проти України, де якраз ці питання підіймаються. Буде дуже цікаво побачити реакцію Комітету міністрів Ради Європи на ці зміни в практиці Європейського суду з прав людини і не тільки стосовно України, а й стосовно інших країн, тому що на розгляді в Комітеті міністрів Ради Європи зараз перебуває близько 10 справ, 10 рішень Європейського суду стосовно Хорватії, Болгарії, Туреччини, Російської Федерації, України і інших, які якраз стосуються питань надання правової допомоги на самих перших стадіях кримінального провадження. Я вас прошу задавати запитання і, враховуючи те, що у нас не дуже багато часу, я хотів би собі дозволити обмежити ці запитання до 2 запитань, тому що у нас ще є наступна доповідь і ще обговорення наступної доповіді. Прошу. Можливо, відразу 2 запитання по черзі тоді, і потім можемо перейти до обговорення. Не вагайтеся, якщо є якісь сумніви, то я думаю, що всі будуть дуже раді обговорити. Тема складна, але дуже цікава.
It's difficult.
Так, будь ласка, я не бачу. Так, будь ласка, будь ласка.
Питання таке, що стосується моменту виникнення права на правову допомогу. Чи є якісь проблеми у зв'язку з цим у практиці Європейського суду?
І можливо відразу друге запитання, якщо таке є. Тобто перше запитання стосовно моменту виникнення права на правову допомогу і... Так. Немає питань стосовно пов'язаних з Кодексом кримінально-процесуальним 2012 року і те, як він імплементується у світлі практики Європейського суду з прав людини, зокрема вимог рішення у справі Солдус, або зараз вже вимог рішення у справі Безе, бо вони змінилися насправді. Якщо немає, то тоді ми зупинимося на одному запитанні. Прошу.
Okay, I will, this is one of the things that is defined in Beurs versus Belgium. Nothing new, it's just repeating the case law that exists from before. And as I know from Croatia, when I'm talking to my judges, prosecutors, especially policemen and prosecutors, for them, that's a big, huge problem, huh? How we start.